Hi there, I'm James Dapachi, and this is Coffee and a Case Note. My offer is that you lose. Today, team, we're going to be speaking about two parties in a piece of litigation. Now, before we dive into the decision itself, let me give you a little bit of background. Often, when parties are in a court dispute, they're going to be exchanging offers. And if I'm trying to claim some money from you, I might say, look, I'm claiming stacks, but I tell you what, in order to compromise my claim, I'm happy to stop it today in exchange for me receiving some portion of that amount from you. So I'm going to compromise what I would have otherwise got. I'm claiming all this, but I'm going to reduce it. And that's often the sort of offer we see exchanged, especially when there are liquidated claims for sort of certain amounts of money. Now, sometimes what you see is an offer that essentially is, I win, but you don't have to pay my legal costs, right? So let's just have a think about that. I might make an offer because the proceedings are before the court, and that offer might say, look, I'm so certain that I'm going to win if we go all the way to final hearing, and when I win, I'm going to get my legal costs from you, that today what I'll say is, look, I'll just win today and don't worry about legal costs. And what I say is, because I'm so certain to win in future, my offer to compromise and just win today without any legal costs is itself a genuine compromise. My offer is you lose, but don't worry about the legal costs. Okay, so let's bear that second example in mind when we talk about today's decision. The court is taken to a defendant who successfully defends a claim against a plaintiff, and the defendant gets an ordinary costs order in its favour. And the court also grants leave for a further dispute about costs down the track, and the defendant essentially accepts that opportunity. And so the defendant goes into the costs dispute and says in that costs dispute, look, I made this offer back in the past. What that offer was, you lose today and we don't have to worry about legal costs. So the second type of offer of those kinds we were discussing earlier. And the plaintiffs didn't accept that offer, and I ended up winning down the track. You know, the hearing happened, we had the big argument, I won, and so it was unreasonable, forgive me, for that offer to be rejected, and it was a genuine compromise. I was compromising the legal costs that I was going to get, and I was always going to get those legal costs because the plaintiff's prospects were so poor. That makes sense? The argument is, because I wasn't going to chase my legal costs, because I offered to waive my legal costs, it was a compromise. Now, what the court said was no, in essence. The court said in some cases, saying you lose no legal costs is a genuine compromise, but in these circumstances, for two reasons, it wasn't. Why? Firstly, at the time the offer was made, there was no evidence about the defendant's legal costs. So the defendant didn't really do the arithmetic and set out the numbers and say, look, these are the legal costs. This is the barrel you're staring down if you reject this offer or allow it to lapse. And the second point the court makes is, look, the plaintiff's claim may not have been strong, but the defendant's victory relied in part on how evidence about certain oral representations was going to fall in the final hearing, which is to say, it wasn't until all the evidence came out before the court that the outcome became so certain. And so that meant that before that evidence came out, it was difficult for the defendant to really argue of, oh, we were always going to win, because so much of the decision was going to turn on what actually happened at the hearing. So for those two reasons, no arithmetic about costs and uncertainty about what would happen at hearing, what was found was that the offer was not a genuine compromise sufficient to increase the costs order that the defendant ended up getting. So the defendant had to be happy with its ordinary costs order, and it failed in its attempt to get an indemnity costs order. And I hope that note was of assistance to you. I hope wherever you are, certainly not in cafes, as the recent directives handed down require. All is well with you, and I look forward to joining you again soon, wherever it may be, for another coffee and another case note. Cheers.